Good morning, Your Honor. My name is Hassanul Haq Raja and I appear before you today on the behalf of the defendant, Ministry of Energy of French Republic and Lotka Energy and BIOS are as the applicant in this case. Between Lotka Energy, BIOS are, these are the claimant applicant, and the Ministry of Energy of French Republic, which I am defending, these are the defendants. Lotka Energy is French company, 34% owned by BIOS, 12% by France, and 54% by TKL UK, doing business with BIOS OAO, which is buying, conveying gas and further distributing in France. By the objection of Ministry of Energy and France that interest of France had been damaged by this supply agreement concluded between BIOS and Lotka. Your Honor, here are some case facts. Number one, Lotka Energy of France doing business of buying, conveying and selling fax in France. Number two, Lotka Energy Company has shares of 34% owned by BIOS, 12% by France and 54% by TKL UK. Number third, in 2015, the Ministry of Energy of France brought an action against Lotka that the interest of France had been damaged by the unfair amendments of the agreement setting the price of the gas purchased from BIOS. Number four, based on the arbitration agreement contained in the Lotka shareholders agreement, BIOS commenced arbitral proceeding in the Sweden before the Arbitration Institute of the Stockholm Chamber of Commerce (SCC) against the Ministry of Energy of France, demanding the arbitral tribunal to order the Ministry of Energy to withdraw the action before the French court. Number five, in July 2016, the SCC Arbitral Tribunal declared an award by directing the Ministry of Energy to withdraw some of its requests, specifically the request for setting a fair price for the gas. Number six, in September 2016, French tribunal upheld the action taken by the Ministry of Energy and decided that it is not a question of arbitration under French law. The respondent A and B both filed appeal before the French Court of Appeal against order of French tribunal, arguing that arbitration should be taken into account. Number 8. In December 2016, French Court of Appeal rejected the appeal of respondent of the basis that denying of jurisdiction of French court is breach of independence of judicial authority state in the French Constitution. Number 9. In February 2017, issues were taken to the French Supreme Court. The Court of Cassation stayed proceedings and referred the matter of CJEU and CJEU for preliminary ruling. Your Honor, here are some documents which I'll share with you. Agreement between the parties. Objection of the Ministry of Energy, SCC Arbitral Tribunal Award, July 2016, the French Tribunal decision, September 2016, decision of the French Court Appeal to December 2016, decision of the French Supreme Court, February 2017, the Court of Appeal relying on Article 528 and B of the 1958 New York Convention, Gazprom case, judgment by CJEU, Brussels 1 regulation, recast 2012, Article 25, prorogation of jurisdiction, Hague conviction, choice of court, agreement 2005, the traditional English rule of the basic common law, where Brussels I regulations does not apply. Here are some, Your Honor, I am going to discuss about the applicatory tests. Article 52A of the New York Convention enables the courts of the contracting state of the refused recognition and enforcement of an award if they find that the subject matter of the difference, which led to the award, is not capable of settlement by arbitration under the law of the country where recognition and enforcement is sought. Number 2. Article 52B of the New York City provides that recognition and enforcement of an arbitral award may also be refused if the competent authority in the country where the recognition and enforcement is find that B. The recognition of enforcement of the award would be contrary to the public policy of that country. However, this convention refers to the public policy of a convention member state, but in practice state, courts have also used notions of transnational and international public policy. De facto, a violation of domestic regulation and law shall not be deemed a ground to refuse the enforcement and recognition of an award. Number 3. In the line with Gazprom decisions case, our case is qualified to be tested in all 4 corners. A. Courts of the member states maintain the authority to examine whether to recognize and enforce an arbitration agreement, hence valuable number of rights are involved. Courts of the member states follow the ruling on the validity or existence of an arbitration agreement, whether it falls within the arbitration exception of recast Brussels. Only arbitration actions themselves fall outside the scope of recast Brussels. Code of France takes a serious question objection on the agreement secure its interest. C. Recast Brussels I do not apply to any ancillary proceedings relating to arbitration or to any action according. So if arbitration proceeding started, it will seriously affect the law of the lands, as in the case the property must be distributed in the state through a legal proceeding where the property is based. D. Following question is referred to the CJEU for a preliminary ruling where an arbitral tribunal issues an anti-suit injunction and thereby prohibits from bringing certain claims to the court of a member state. Does the court of that member state have the right to refuse to recognize such an award of the arbitral tribunal because it restricts the court's right to determine itself whether it has jurisdiction to hear the case under the rules of jurisdiction in the recast Brussels regulation. Ministry of the Energy acknowledged that it has a good arguable case in support of the application on the ground that refusal of this jurisdiction of France court is breach of independence of judicial authority. Your Honor, here are some dispute points of the case. Nonetheless, the decision of the Court of Appeal for both parties is subject to appeal in cassation before the French Supreme Court of Cassation. The Court of Cassation stayed proceedings and referred the queries to the CJEU for the preliminary judgment. Number 1. The relevant Article 52A and B of the 1958 New York Convention, according to the CJEU judgment of Gazprom case, our case is qualified for the test in all 4 corners. Number 3. If an arbitral tribunal issues an anti-suit injunction, thereby constrains a party from bringing claims before a court of a member state. Number 4. If the court or member state have the right to refuse or to recognize such an award of the arbitral tribunal because it restricts the court's rights. Number 5. If the court of member state has jurisdiction to hear the case under the rule on jurisdiction in the recast Brussels regulation. Number 6. If there is a personal jurisdiction over the respondent by the English court. Number 7. If the English court has a sufficient interest in the proceeding to justify restraint foreign proceedings. Number 8. If relief could be made out under legally appropriate ground. Number 9. In case the absolute requirement is made out, whether it is pertinent to award the injunction as matter of destruction. Your Honor, here are some pledge undertakings. Hence, it is acknowledged that is imposing the application for freezing injunction, the court shall require to relevant undertaking from the French government to which French government is consenting to provide all necessary undertakings to the court. Your Honor, here are some jurisdiction arbitrations. 1. The matter shall remain within the jurisdiction of this court. B. Application for relief by the French government to grant an interim injunction constraining bio or OAO from disposing or dealing with the value of its assets if they are in or outside the jurisdiction level to the same value. Number C. It is not necessary precondition from the grant of the order that buyers are have any assets within this jurisdiction. Such injunctions are applicable to the assets which are located outside France and or may apply to such foreign assets instead of or in addition or to assets within the jurisdiction. Number D. The code could order mandatory obligation on buyer or company to transfer valuables into the jurisdiction. E. In line with Article 5.2 of the New York Convention, a person residing in one member state may be used in another member state. According to Article 5.2, it is impossible to distinguish between a person whose right to maintenance payment has been recognized and a person whose right has not yet been established. As a result, the concept covers both a person whose right to maintenance has already been established by the prior judgment as well as the person who is applying for maintenance for the first time. Farrell versus Long C. Your Honor, full and frank disclosure. The documents of agreements and articles are presented to the court for just closure. Further, Article 5.2a and 5.2b support the view of petition and qualify the tests. So here are my prayers and conclusion. In the light of the arguments stated above, it is requested that a legal order of granting a freezing injunction in opposition to the buyers or incorporates a penal notice along with warning to the petitioner in case the order has been breached. The prayer of the respondent is that the matter should be decided in case of an issue. All the parties come under the jurisdiction of Court of France under the rule of jurisdiction. In the RCC, both parties are the member state of EU. If the matter be sent some other place than France, both parties endure loss or as more loss on behalf of the Court of France. Consequently, we wish the matter be heard and decision in within jurisdiction of France as it is in the clear intent of all the parties. 10 July 2022, Raj Chambers. Thank you, sir.